Williams 23-02992. Council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Assistant Public Defender Sarah Donnelly on behalf of defendant Asa Williams, to my right.
Okay, Mr. Williams is scheduled for jury trial today on an attempted assault. Are we running a trial?
Your Honor, at this time, Mr. Williams would like to plead as charged.
Okay, off the record, I gotta go through these files first before 9 o'clock and then I'll
Okay.
take it.
Okay, all right, just sit down for a second.
On the record in the matter of the people of the state of Michigan versus Quan Wheeler, 24-02099. Council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Wheeler.
Okay, Mr. Wheeler scheduled today for a jury trial for an assault and battery. Are we continuing to trial today?
The people are unable to proceed on this file today, Your Honor, because the victim is not present, so I expect the council to make a motion.
Motion would be to dismiss.
Motion to dismiss is granted without prejudice. The people do have the right to reissue this charge against you. Do you understand that right, sir?
Yep.
Do you have any questions for the court? We'll get you a copy of dismissal in just a moment. Any additional matters for the record?
Not for the people, Your Honor.
Oh, Your Honor.
You're all set. Thank you.
Forgive me, before, I know we have more files to go through, but just thinking ahead to Williams, we're not gonna need a plea sheet on that because he's gonna plea as charged, is that right? Or would the court still need a plea sheet?
We're talking about for, yeah, you're correct. If he's pleading on charge, I don't need a plea sheet.
Okay, thank you.
Okay, on the record in the matter of the state of Michigan versus Betsy Sue Bailey, 24-02394. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
And Assistant Public Defender Sarah Donnelly on behalf of the defendant Betsy Bailey, who is to my right.
Okay, Ms. Bailey was scheduled for jury trial for false report today. How are we proceeding?
Your Honor, I've been in touch with my witnesses. We are prepared to continue the trial this morning.
We are as well.
Where are your witnesses?
The witnesses in this case, Your Honor, are police witnesses.
Okay, all right, so we'll call on a jury for this matter. Please take close by, okay? Any additional matters we should address before we go off the record right now on this?
Not for people, no.
Not for defense.
Okay, thank you. Back on the record in the matter of the state of Michigan versus Asa Williams.
If Miami approach with the advice grades.
Thank you. Okay, Mr. Williams, my understanding is that you want to plead to the original charge. Is that correct? Can you speak loud enough so that we can hear you? Thank you. Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes.
You can put your hand down. Okay, so you're being charged with a police officer assault resisting obstructing. This was amended to an attempt, is that correct?
Yes.
Okay, this was amended to attempting, restricting, resisting, and obstructing. You want to plead guilty to that, correct? And you understand the rights listed here in this document that you signed? So you're willing to give these rights up in order to plead guilty? Anyone threatening you to get you to give those rights up?
No.
Has there been any promises extended to you if you give up those rights?
No.
So you're gonna give up your right to be presumed innocent until proven guilty beyond a reasonable doubt?
Yes.
That means you're giving up your right to have a jury trial, which you were scheduled for trial today. You have the priority case, meaning your case number was the oldest, you would have went first before the other one that we're going to proceed on. You understood that?
Yes.
And you have the right to require the prosecutor prove each element of the charge being brought against you beyond a reasonable doubt. You could remain silent at that trial and they could not use that silence against you. You could testify at your trial if you'd like. You could have called witnesses to testify on your behalf. You understand that?
Yes.
Okay. Are you currently on probation or parole?
No.
You understand that by pleading guilty, it could result in a conviction that you may need to report to your current employer, or you may need to put this on a future job application.
Yes.
It also could have impact on any travel or immigration status that you may seek. You understand that?
Yes.
As to the charge of attempted resisting, obstructing an officer, how do you plead? Factual basis, counsel.
Thank you, Your Honor. All right, Mr. Williams, on September 28th of 2023, were you at or near your home at 3436 North Waverly Road in the city of Lansing, Ainton County, Michigan?
Yes.
All right, and at that time and place, did you come in contact with the officers of the Lansing Police Department?
Yes.
And you knew they were officers because they were in their full uniforms, right?
Yes.
And you had no reason to doubt that they weren't performing their duties, correct?
Yes.
And did they give you a lawful command to, well, did they try to detain you
Yes.
for an investigation?
Yes.
All right, and they believe that they had a reasonable suspicion to stop you for an investigation, correct?
Yes.
And you, and then as a result of that interaction, you did attempt to resist or disobey those officers' lawful orders?
Yes.
All right, Your Honor, no further questions.
People are satisfied.
The court is satisfied with the factual basis. I'll accept your plea and I find your plea made free voluntarily and intelligently. How much credit does he have on this?
I have that he has a total of 22 days that he's been in custody. Over various incidents. Let me see here.
I have a couple of stories from peers, and I think at one point he was in custody in another county.
Yes, I have him giving 1 day at arraignment. He had, I think, 11 days in November, and then another 10 or so in August, from August 30th to September 6th, when he was released without any reason. We don't know why. And then, you know, we had a court date and he still showed up, so.
Okay, this matter is set for sentencing March 24th at 9 o'clock in the morning. When you leave here, you're gonna go down 1 floor to our probation department and check in so that they can get you prepared for a pre-sentence interview. Do you have any questions for the court today, sir?
I have a question, Your Honor. What was the time of the sentencing on the 24th?
9 a.m.
9 a.m. All right, and another one, Mr. Asa, or Mr. Williams has a surgery on his hand this morning, scheduled at 9:30. If he has to go for that, can he come back after the surgery, like today or tomorrow, and report to probation?
Within 48 hours.
Within 40 hours, okay.
We'll get your notice prepared and you'll be all set for today, okay?
We'll keep that to the probation.
We need an updated complaint, I believe, probably. I don't know. Okay, on the record in the matter of the state of Michigan versus Bashir Ahmad, 24-01052. Appearance, please.
Good morning, Your Honor, Matt Nagel for the people.
Assistant Public Defender Lauren Sutter on behalf of Mr. Ahmad, who is approaching council table now with the court interpreter.
Can you raise your right hand? Do you solemnly swear or affirm to interpret in the matter before the court completely and accurately and not divulge confidential communication? So help you God. Thank you. Today was the date set for a final pretrial. And this is for an assault and battery. We have witnesses here.
Your Honor, necessary witnesses are not present this morning for this case. Therefore, the people are unable to proceed, and I expect the best to make a motion.
I would make a motion to dismiss, Your Honor, based on that information.
Motion to dismiss is granted without prejudice. The people have the right to reissue this charge against you. Do you understand that?
Is it sold completely? No.
Stand up for the court.
Him and she had. Yes, I did.
Any additional matters for the record?
Nothing further.
We'll get you a copy of the dismissal in just a moment. The record in the matter of the state of Michigan versus Jeffrey Anderson, 24-03412, council appearance.
Matt Nagel for the people.
Mr. Anderson does not have an attorney, is that correct?
That's correct.
Mr. Anderson today was scheduled for final pre-trial. This is for malicious destruction of a building and breaking and entering without an owner. We have witnesses here.
Your Honor, I checked, and there is no witness present on this matter, so I expect the defendant would want to make a motion.
There's no witnesses. You want to make a motion to dismiss for their inability to proceed.
Yes.
Okay, your motion is granted, but I have to grant it without prejudice. That simply means that they do have the right to reissue the charge if the witness re-engages and wants to proceed, okay?
How do I pay for the damage?
You just call out, you just speak to the victim.
Okay.
I was gonna say, we aren't ordering anything, but if you have an outside agreement, that's different, okay? I'll get you a copy of this dismissal for your records, okay, sir?
Okay, thank you.
You're welcome. September 12th. On the record in the matter of the state of Michigan versus Laura Lee Bacon, 24-03519.
Good morning, Your Honor, Matt Nagel for the people.
Probably, on behalf of Ms. Bacon.
Okay, this matter was scheduled for final pretrial. This is for assault and battery. There was a Killaboo North Front Jail or to agree to treatment. As witnesses here.
Witnesses are not available this morning, Your Honor. People are unable to speak. Right.
Motion will be to dismiss.
Motion to dismiss is granted without prejudice. The people can reissue this charge against you. Do you understand that? I don't understand.
Yes, I do.
Thank you. Do you have any questions?
No, I do not.
We'll get you a copy of dismissal in just a moment, okay?
Thank you very much, Sharon.
You're welcome. Matter of the people of the state of Michigan versus Leila Mae Dalton, 16-04106. Appearance, please.
Good morning, Your Honor, Matt Nagel for the people.
Jacob Riley on behalf of Ms. Dalton.
Okay, Ms. Dalton had a malicious destruction of personal property less than 200. What witnesses here?
Witnesses are not available this morning, Your Honor, therefore I expect the defense to make a motion.
Defense motion to dismiss, Your Honor.
Motion is granted without prejudice. They do have the right to reissue this against you. Recognize that?
Yes.
Do you have any questions?
No.
Okay, we'll get you a copy of dismissal in just a moment. Of the state of Michigan versus Jennifer Rose McEwen, 24-03360. Appearance, please.
Good morning, Your Honor, Matt Nagel from the people.
Jacob Riley on behalf of Ms. McEwen. Ms. McEwen is not present today. I can inform you that she has emailed me this morning, said that she's currently hospitalized. Waive explanation for her absence.
She emailed you to tell you she was hospitalized.
Yes,
Oh,
she checked in this morning.
People do have a witness present on this case this morning, Your Honor. I would ask that for purposes of final pretrial, that this be left set for jury trial.
she's a mission of bench warrant. She should be remanded. I don't accept emails that you're in the hospital. We need verification from the hospital that you're in the hospital. This is set for jury trial. When?
I believe perhaps March 3rd. if I'm not mistaken.
I don't think I wrote the note down when it is. Is it February? I have February 24th. What's that?
I don't.
I do have the 24th.
I do as well.
Okay. I'll note here that the witness did appear, that a bench warrant will issue with remand until jury trial, unless I get proof otherwise that from the hospital that she is hospitalized. If that is the case, then I'll adjust the warrant issue. Any additional matters for the record?
Not for the people, Your Honor.
Oh, you're right.
Thank you. You're all set on that one. So leave the date. We'll leave the dates in. Yeah. On the record in the matter of the state of Michigan versus Tommy Taylor, 24-03587. Appearance, please.
Good morning, Your Honor, Matt Nagel for the people.
Jacob Riley on behalf of Mr. Taylor.
Mr. Taylor has an assault and battery final pretrial today. We have witnesses.
There are no witnesses present this morning on this matter, Your Honor. Therefore, people are unable to proceed. I expect the
This motion is to dismiss. Your Honor.
We'll have to start making the prosecutor bring a stack of dismissals. This is about a ream of paper. Okay, let's see here. Your motion is granted without prejudice. The people do have the right to reissue against you. Do you have any questions about that?
No, ma'am.
We'll get you a copy of the dismissal in just a moment. Okay, I think that's all the final pretrials. Did I miss one? No, I did not.
Did we address the jury trial set for DS Plans?
I was gonna schedule it for the day you're doing, but I have to remove her date, but now I gotta. Who are we addressing?
Carlos Diaz-Torres is not on.
They're not on my docket.
Oh, is that removed? Okay. I guess that was, we had agreed to an adjournment, but I don't think we'd heard
Okay.
a ruling on that.
On the record, in the matter of the state of Michigan versus Kyle Norton, 24-03565.
Morning, Your Honor, Matt Nagel for the people.
Noah Thalen on behalf of Kyle Norton, who's present in the courtroom.
Okay, this matter was scheduled for pretrial for domestic violence, and then I have a bond violation here. Let's see, the allegations, Mr. Norton, that you violated the conditions of your release from custody by having contact via text message. The protected party, Holly Wojciechowski.
Mikovich, ma'am.
Makovich, okay, thank you. The allegations are that on or about the 13th of January at 1834, the defendant violated the conditions by sending a text to Holly's mother asking her to deliver a message from Holly to Holly from him, which would be in direct violation of your bond conditions. Your bond can be revoked pending any hearing on these allegations. You could, if found to be guilty of the violations, be sentenced to contempt of court that's punishable by 93 days in jail and or up to $7,500 in fine. You understand that?
Yes, Your Honor.
Okay, I'm reading the allegation on the report. Is the allegation, I believe the report was on the 13th. The allegation is that the text was sent on the 7th, just to correct the record of January. It is an allegation that the defendant made contact to have, I guess, the mother pick up the child from school. I'm not going to proceed on this bond violation because it's not meaningful to me. I will, however, remind you of your bond conditions so that you don't find yourself in any issues. Whether or not this happened, if it did happen, it was no harm. It looks like it was allegedly trying to get your child picked up from school, and that there's usually an app that's used. I don't know why this was reported, but nonetheless, just be safe, follow the rules so that you don't get in trouble, because it sounds like someone's being vindictive. Let's see. As to the underlying issue, how we proceeding.
Today's set for a pretrial. I have not had a chance to confer with the defendant's attorney prior to today, but I would ask that he reach out to me so we can discuss this, and potentially we can either leave this on for a second pretrial or continue the final pretrial. I will point out that the victim is here this morning without a subpoena, so just for counsel.
Your Honor, I believe that we can set it for a second pretrial. I'll reach out to Mr. Nagel here in about 5 minutes. I have a hearing in 55th that's at 9:15, so I'll reach out here and right as I'm walking into Mr. Nagel, and we'll email the court from there.
Sounds good, thank you.
Thank you.
February 24th at 10:30.
February 24th at 10:30. You said your witness is here today?
She is, Your Honor, without a subpoena.
Okay, after the parties had an opportunity to discuss whether or not this is a matter that can be resolved. If it's not, you can email the court and we can convert this to a jury trial, or get your jury trial date instead of proceeding to final pretrial if it's not going to be resolved.
That sounds good. Your Honor.
Thank you, Your Honor. Have a good day.
Thank you, you're all set. Thank you. That Mr. Nagle, unless you were making a record for something.
I will not.
Okay, on the record in the matter of the state of Michigan versus Gabriel Williams, file number 24-03207. Appearance, please.
Probably we have Mr. Williams on.
Okay, Mr. Williams has a sentencing today. I do have a pre-sentence report that was prepared on the 21st of this month. Counsel, did you get a copy of it?
Yes, ma'am. I have reviewed that report with my client.
Need to make corrections, updates, or deletions.
We have none.
You can make allocution.
Your Honor, I think certainly I know that this is not an acceptable thing. It's not acceptable behavior. He has learned that he needs to be more in control of his decisions, and certainly he regrets what happened here. He's very apologetic for the victim in this case. I certainly know he does not want to go through this process and be proven liberty. I'm confident that this is not something that's going to be repeated, but generally speaking, I do think the recommendations of the report are clear and appropriate, and that's what the job is.
Mr. Williams want to make a statement?
Oh, apologize for what I did. Be going through nothing like this again.
Okay, the pre-sentence report and the recommendation advise that you are employed, but you only make $300 a month.
Yes, I'm moving company, my granddad's.
Okay, so why don't you have a full-time job, sir?
Cause I actually lost it, cause I had went to jail for like a week. I lost the job I had. I was at Myers Warehouse in the freezer. I lost that job because I was gone for a week.
Okay. And then, let's see, I don't know why the report goes in such detail about 769.4. I don't think we
And that would have been appropriate in this case.
agreed. Check by accident, that's probably why. Okay, let's see here. The recommendation is for a 10-month term of probation. It's for since it's recommended the defendant complete anger management program and moral recognition therapy. That the probation officer additionally requests that the defendant submit to random testing as directed and maintain employment.
I do have a question
Okay, what's your question?
about the anger management class.
Yeah. How is that a question? What's the question? You mean you have a statement?
Yeah.
And your statement was to tell me what you believe you need. Oh, tell me what else you believe you need. You don't think you don't have anything else that you believe you need?
No, ma'am.
I believe you need a job full-time. That's my primary
Yeah, I
concern.
got a interview tomorrow.
Well, you do?
Yes, ma'am.
Well, that's positive. Let's see here. What's so funny?
It was an honest statement. It was funny.
What was honest?
I need a job, but
That's, I just wanted to know if you thought that that was something that you needed.
no, most definitely.
Okay, why do I have a restitution form? Is there restitution owed in this? Because there's no amount on it.
Oh, I'm not aware of any requested restitution in this case.
The other thing is, you don't have any adult convictions
No, ma'am.
on your record. I don't see any assaultive convictions other than this. It's the first one, and so that's the basis upon which you believe you don't need
First and last.
first and last. And is it the circumstances surrounding the incidents why you believe you don't need anger management?
Yeah,
Yes.
yes, ma'am.
Okay, I vaguely recall the factual basis, but I do have a copy of the police report. And the concern was that, or at least as it relates to the police report, that this might have been some level like retaliation about another incident.
Yes.
Okay, and so you believe that that's why you don't need anger management?
Oh, yeah, I'm perfectly fine. The person that it happened to, I'll stay clear from them. I'm not really.
Right, but the anger management, the goal of it is not so that if you see that person again, that you are able to maintain control. It's if you find yourself in heightened emotional situations similar to that.
I'm pretty level-headed with situations. And, I'm really patient with myself, my anger.
We understand that. I'm glad that you're patient with yourself. Now we want you to be patient with others. That's not necessarily been demonstrated through your previous actions.
Yes, ma'am.
You recognize that, correct?
Yes, ma'am.
Okay, and as of right now, I don't see that you're doing anything else that would prohibit you from being able to participate in anger management because you're not even working. You got a lot of time on your hands. Why not learn some new skills?
I really take care of my kids. So that in school is kind of a hassle for me.
Because you take care of your kids and you go to school?
Yeah, I take care of them by myself.
Okay.
Hassle for me.
It should be a hassle for you to be in court.
Yeah.
Being on probation shouldn't be the hassle. Because it could be a hassle for you to serve the remaining 93 days in jail. That would be a huge hassle. You have full custody of your children?
Yes, I do.
Okay. How many children do you have?
3.
So you have 3 children that you have full custody of and you don't have a full-time job. That's even more concerning. You gotta get a job if you're gonna provide for them. The recommendation is for 10 months of probation. I think that that is excessive under the circumstances. I am going to cut that in half. I'm going to sentence you to 5 months probation. Rarely, because when you're on probation for an assaultive action, you can't request early discharge. So I'm going to give you half the time now versus 10 months. I can always increase it if, for whatever reason, you're not compliant, but I don't think that's going to be an issue with us. Okay, while on probation, you need to get a job and provide evidence that you have a job. There's a $30 per month oversight fee that you're responsible for. You're not to engage in any assaultive or threatening behavior. You're not to have contact directly or indirectly with the victim, Wayne Woods.
Yes, ma'am.
You're not to purchase or possess a firearm, ammunition, or weapon of any kind while on probation. I'm assuming maybe this was placed. That's it, but the fact that it was charged as an aggravated assault, I don't see any amounts for restitution, so restitution will not be ordered. The report via Zoom for probation.
I did have a question.
Yes,
Is there a way I could just pay the $30 fine? So,
Okay, we'll talk about that in just a moment.
Okay.
Let's see here. There's a $75 crime victim rights fee that's also going to be assessed, plus a $50 state minimum cost that must be assessed. Your total fines and costs is $275. You pay it all in once, or you can make monthly payments. I'm not gonna order substance abuse testing at this time unless for some reason it becomes an issue. You're not to, however, use, purchase, or possess controlled substance all without a valid prescription. I'm only addressing that because they lumped it all together. However, I'm not ordering that you do any testing. For some reason, your probation officer over the course of your time believes that it's an issue, then I'll have to order testing, okay?
yes, ma'am.
My primary concern at this point is that you get gainful employment. I don't believe you need case management either based on the nature of the charge, or I should say the underlying issues that brought about this charge, as well as why, as well as your prior criminal history. I don't see any assaultive actions there. So I'm hoping that you've learned from this, because you've definitely, that's not a whisper, so you're really interfering with my ability to think right now. Can you all, excuse me, can you all take that over there just because it's loud? Okay, so there is nothing else on your record that would indicate that this is a pattern of behavior. However, your record, at least 10 years ago, sounds like you did have a sort of history, but there was nothing in that gap between now and then. So you had nothing in your adult history. Unfortunately, this is the first and hopefully the last time you'll be engaging with the criminal justice system in this regard. You'll check in with probation when you leave here. You'll go downstairs to check in with them. And I've already addressed this in brief, but you do not have the right to request early discharge from probation, okay?
Yes, ma'am.
And I've already, well, no. You do have the right. You're not on for domestic violence. That was in this check on here. You're on probation for aggravated assault, so you would have the right to request early discharge. You have to complete half the original term that's ordered by the court, no violations within the 90 days preceding that request. And then you could make that request by using the court's MC 512 form, which is on the court website, or you can get it from your probation officer. You would complete that form, file a copy of it on probation, and then you also must serve a copy or get a copy to the prosecuting attorney's office. They have 14 days to respond in writing to any objection to your request for early discharge. If I set it for a hearing for early discharge, you would have the right to hire an attorney to represent you for such matter, but you would not have the right to any court-appointed counsel for a hearing of that sort, okay?
Yes, ma'am.
Do you have any questions about your right to early discharge from probation?
No, ma'am.
I need you to initial so we know that we went over that with you and you can get that back to me.
Right at the bottom.
Yes. That he's what?
He's not.
He's not. They have him in there?
Yeah, try to put it.
Thank you. Why did I let him know? I'm not sure. No, I don't believe he's eligible for any special status. I could be wrong. They only addressed 769.4A multiple times. I don't know whether they have that in. Yeah, I think they put that in there by error. We'll get you downstairs in just a moment, okay?
Yes, ma'am.
Thank you. something?
I do have Ms. Trine who's, Ms. Trine who's here and ready to go on that case, Your Honor.
Bakari Bryant.
Oh, yes, he's
Michael
also here.
Rodney.
Right, is here
Yes.
on the record in the matter of the state of Michigan versus Bakari Bryant, 24-02487.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Bryant.
I have a pre-sentence report prepared for today's sentencing of Mr. Bryant. It was prepared on the 21st of this month. Counsel, did you get a copy?
Yes, Your Honor, I have reviewed this report with my client. We have no additions, deletions, or corrections.
Okay, you can address the court.
I think, to begin with, I do think probably the recommendations of the report are fair. My client certainly has a recurrent issue with alcohol that needs to address the situation. Certainly not to place himself and others in danger as a separate. So I would ask the court to adopt the recommendations.
Does your client want to make a statement? You really have nothing to say. Well, why don't we start with why you missed 2 appointments to have your interview with probation, and how you believe that despite the fact that you are not responsible or had not been responsible, that you will now be responsible if I put you on probation.
Just happened to oversleep. So then the first time I had the date in my calendar wrong.
On the 10th, you had the date in your calendar wrong. Oh, you supposed to report at 11 o'clock on the 10th. Said you failed to report, and it looks like it was rescheduled to the 20th at 10:30, and you overslept. How did you oversleep?
I don't sleep at night like that. Yeah. Very late.
Okay, I didn't ask you time you went to sleep, but I want to know why weren't you up and ready to be where you need to be? Do you work, sir?
But not now. I'm currently just looking for another job. Delivery job.
How long have you been unemployed? How do you earn a living? How are you earning a living then?
Help people out sometimes.
Helping people out sometimes is enough to earn a living?
Right now.
You don't have a living,
house right now.
I'm sorry, what?
I don't have a house right now. Staying with people.
You're staying with people, but you still have to live, you have to eat and buy clothes or other
I
things,
have
correct?
tons of clothes.
Yeah, but you still have to eat, correct? Is that a yes? And is it your goal to live with other people long term? So then you do have a living to
I
have.
mean, this just started. I ain't been living with people my whole life. Started recently.
What's recently mean? Your address changed in October?
That's when I moved. So I moved out my apartment November 1st.
The report opines that there's a concern about your follow through with your ability to keep your appointments with the court and treatment, that they believe that you do or would benefit from some treatment, and that the defendant, well, there's some additional concerns surrounding the defendant's self-admittance of continued criminal behavior. I'm assuming they're talking about substance use. It said it should be noted that the defendant has had 2 or more substance abuse convictions in the last 7 years. As a result, his driver's license has been revoked. During the interview, the defendant reported that he drove himself to the pre-sentence interview on the 30th. With a revoked license. It says he additionally reported he is aware that his license has been revoked, yet continues to make the choice to drive for his job on track. So means that must have been where you were working. And so this gives the officer concern, reasonable, that as to what other criminal behavior the defendant is engaging in. Let's see here. They're recommending I'm sorry,
I guess I'm just this bad guy.
that's not what the
That's
report
what they
says.
said.
That's not what the report says. The report says it has concerns and it's reasonable because you know your license is revoked and you violate the law to court. You don't care that your license is revoked, you're gonna do what you wanna do.
No, I care.
Well, then why are you driving?
It's hard to find a ride.
I don't dispute that it's difficult to find a ride, especially in Lansing, where there's not a really great public transportation infrastructure. And I don't know what your family resources are, but these
My
are
family's
the,
not from Lansing.
I can imagine, but these are the results, the direct results of actions you took. Your driving privileges were revoked because of actions you took. You were the person who made it or created an atmosphere where it became more difficult. And so now there's some roadblocks that you would need to get around if you want to now demonstrate to the Secretary of State that they should give you those privileges back. And what you're doing now is the actual opposite of how you can get your license back. And so you got to get to a place where you decide that I got to make some better decisions and I'm going to really push myself forward into doing that, even if it's difficult. But that's up to you, sir, because if you don't, these little small actions could amount to bigger actions. You get arrested for driving while license suspended. You could get a new job and get arrested. And now you're back in jail, you lose a job. You see how the cycle can continue?
I get a new job, how I'm gonna get there.
That's not for me to answer. You're the one who got your license revoked. I don't have to tell you how to get to work. I tell you how to follow the law. You figure it out because you had 2 substance abuse related incidents in 7-year period, which means we can't put you on the road for safety of others and safety of yourself. So you might have to Uber to your job. You might have to figure out a carpool situation. You might have to walk to your job. I don't know. That's for you to figure out. You're a grown man. You got to navigate the challenges that you created for yourself in a society that already had enough challenges for you. So don't ask me how you're supposed to be responsible. You figure it out. That's part of being an adult. You figure it out. They're requesting that you be placed on a term of 14 months probation. It said it would be recommended that he follow the recommendation of substance abuse assessment and complete intensive outpatient treatment. And that additionally, the defendant attend 2 times a week, 12-step support group and submit to random testing and scram alcohol tether for 90 days. Lastly, this officer would recommend the defendant gain new employment that does not require driving a motorized vehicle as the defendant's license has been revoked. I don't even know how you get a job that requires it if your license has been revoked, but that's for you to figure out. I am going to adopt the recommendation. Will be sentenced to a term of probation. While on probation, you have the following conditions. You're not to engage in any assaultive or threatening behavior. You're not to possess a firearm, ammunition, or weapon of any kind. And you're not to use, purchase, or possess alcohol, marijuana, or controlled substance unless you have a valid prescription, okay? Is that a yes? You will be required to submit to random preliminary breath testing and or your analysis testing, and you are responsible for the cost of that, and you're not to be at any bars or nightclubs while on probation. Do you have any questions so far? Okay, you will be required to participate in some outpatient treatment. So, or that you do intensive outpatient treatment and that you engage in a 12-step meeting 2 times a week. You have to provide verification of that to your probation officer. You're also going to be required to find a job and maintain the job. It's a $30 per month oversight fee for each month of probation. 14 months of probation at $30 per month is $420. Says that you owe $100 assessment fee, so you must have had your substance abuse assessment done by probation. That will be assessed. $100 MSP fee. Prosecutor recovery costs and $120. That will be assessed. A $75 crime victim rights fee per statute will be assessed. Plus a $50 state minimum cost will be assessed. I'm going to waive discretionary fines and costs at this time. And then they're asking for a scram tether for 90 days. That might be to your benefit since you don't have, it sounds like, reliable transportation. I will grant that request, order you to have scram tether for 90 days. So while you're on scram tether, you will not have to do random testing, okay? Do you have any questions for the court about your probation at this time? 14 months, but I'm giving you this here. This will advise you of your rights as it relates to early discharge from probation. You're being placed on a term of probation before the 54A District Court, and your terms and conditions are specifically tailored to your assessed risks and needs, except for domestic violence, criminal sex crime, or stalking offenses, or an offense where the defense of guilty but mentally ill was asserted. You can request early discharge from the probation once you've completed half of the term ordered by the court. So after 7 months, if you've not violated within the 90 days prior to that request, and you've been compliant with all of your programming, including getting a job, then you can make a request by using the court's early discharge from probation form, which is on the court website, or you can ask your probation officer for it. You would complete that request form, give a copy to probation, and a copy must go to the prosecuting attorney's office from you. The prosecuting attorney's office will have 14 days to respond in writing to any request that you make for early discharge. If I set it for a hearing, you have the right to hire an attorney to represent you for any such hearing. You do not have the right to court-appointed counsel for any hearing for early discharge, okay? You have any questions about those rights? The total fines and costs are $865, so you'll be required to make monthly payments on that. It's about $61, $62 a month. Down to probation, so you can check in before you leave. What's your home address? Your home address? Where are you staying?
House to house.
Where do you receive your mail?
Mail is on hold.
Your mail's on hold at the post office? And no, you don't have a PO box? Thank you. You can have a seat, we'll get you down to probation. If we not seen Michael Jobney
Oh, Michael Drovney is here.
on the record in the matter of the state of Michigan versus Michael Jobney. This is 24-02257, appearance, please.
Good morning, Your Honor. Matt Nady for the people.
Jacob Riley on behalf of Mr. Drovney.
Mr. Jobney, you have a sentencing today. I have a pre-sentence report. It's prepared back on the 21st of this month. Any corrections or updates on this?
We have none, Your Honor.
You can make allocution.
Well, I do think the court is probably fair and accurate. I think certainly my client is regretful about what happened. He also wants to be more in control in stressful situations, especially family conflict situations. I don't think this is going to be a continuing issue going forward. But in general, I would ask the court to adopt the recommendation of the pre-sentence report.
You're on probation right now at circuit court.
Yes.
Until when, June 2026? When are you on probation till?
Can't remember.
It said 18 months of probation. When did you go on probation?
Months ago, I think.
Counsel, are you aware?
No, Your Honor, I don't have any information on that case. It appeared that he was not represented by our office on that matter.
You had a private attorney on that?
No.
Actually, no, that was 29th Circuit, so he wouldn't have been represented by this office. Okay, let's see. Recommendations for you to complete a term of probation here. Although it says that he is being supervised by the 30th Circuit Court. I think that might be why I had the confusion. I don't know how. Yeah, or why, I should say, you would have a conviction in the 29th Circuit and probation supervised by the 30th Circuit. That might be, maybe it's a typo, I'm not sure. Nevertheless, I will adopt the recommendation that you will do 6 months probation here at the district court while on probation. You will complete a moral recognition program. Continue your mental health counseling. And obtain employment and provide verification of that to probation, okay?
Okay.
You're not to use, purchase, or possess alcohol or drugs unless you have a valid prescription. I believe you've already provided a medical marijuana card.
Yes, ma'am.
You're not to possess a firearm, ammunition, or weapon of any kind, and you're not to engage in any assaultive or threatening behavior while you're on probation. There was no restitution on this, correct?
Aware of any request for restitution? Your Honor?
I'm gonna continue in the contact order with the victim. All Labowitz. Not to be in any bars or nightclubs while on probation either. Do you have any questions about those conditions?
No, Your Honor.
While on probation, there's a $30 per month oversight fee that you're responsible for. I'm putting you on 6 months probation, so that's $180. It's a $75 crime victim rights fee that must be assessed per statute. And a $50 statutory state minimum cost that's also going to be assessed. And I will waive discretionary fines and costs. Total fines and costs $305. You can make monthly payments on that, okay? And lastly, you have the right to request early discharge from probation once you've completed half the original term ordered by the court. You would use the court's NC 512 form, which is on the court website, where you can get a copy of it from your probation officer. You must have completed half the original term, no violations within the 90 days preceding the request. You would serve a copy of your request for early discharge on the probation department and a copy on our prosecutor's office. The prosecutor's office would have 14 days to respond in writing to any request for early discharge, okay?
Okay.
If I set it for a hearing, you have the right to hire an attorney to represent you, or you can represent yourself for any hearing for early discharge, but you would not have the right to court-appointed counsel for any hearing. Do you have any questions about those rights?
No, Your Honor.
Okay, let me get you an initial that you receive information about those rights. I'll get you downstairs to check in with probation before you leave. Any additional matters for the record?
All right.
No, Your Honor.
Okay, you're all set. Thank you.
Thank you.
Keita just when you really said there was a restitution form in this file. She said this is why. So they do this here. They do.
For the prosecutor, I don't have anything, just give it to. On the record in the matter of the state of Michigan versus Lisa Trine. 22-0286 and 22-03407.
Maybe for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Trine, who's standing to my right.
Okay, these are pre-trial. Are we proceeding on this?
If I may, Your Honor, I believe we adjourned once before because I was awaiting discovery in these files. I have received discovery in one of the files, 22-02866. I am still waiting discovery in the remaining file. However, regarding the file ending in 866, in my review of that discovery, I did discover a conflict of interest. I have represented a co-defendant in that case, so my office is unable to continue representation. We've already begun seeking conflict counsel from this time. We have not received an answer by today's hearing. I'd be seeking an adjournment in both files so that we can gain conflict counsel in one of the files so that I can get the remaining discovery in the other file.
Sounds good. February 24th at 10:30. February 24th at 10:30 was the new court date. Do you have any questions today, ma'am? I don't know. Sorry? Okay, we'll get you a notice to appear. Any additional matters for the record?
Not for the people.
Nothing further.
You're all set. Team DeMarcus Mushat. Andre Susana present. Jasmine Ward. State of Michigan versus Jasmine Ward, 23-03283, 8485, and 24-00479.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Ward, who's standing to my right.
Okay, these are some dog vaccination, dog at large matters. How we proceed on these?
Your Honor, the people have been made aware that licenses are now current on the animals, and with respect to the at-large, the location of the animals and management have been transferred. Therefore, this defendant is now compliant with the law. And because of that, the people would move to dismiss on files 03283, 03284, and 03285. I believe that's a ticket.
Sure, I think you're all citations. Yeah.
Are they all, because 479 SM, it looks like I might need to submit a note, I'm not sure.
Yeah, we do the amount. Okay. You're dismissing all, correct?
That's correct, Your Honor.
No objection.
Those will be dismissed. We'll print a dismissal on the other.
Thank you, Your Honor.
threatened? Prior to custody? Prior to custody?
Yes.
Yes.
Okay.
I'm looking like that.
Do you know what we're doing on that one?
It sounds like this is going to be a plea, Your Honor. Also, I'm sure we'll do this on the record, but it also sounds like he's got 6 months in Clinton County, so the people are gonna make no objection to immediate sentencing if the court wants to do it.
I have Malik brought up, please. And then have we seen Kenneth Bledsoe? On the record in the matter of the state of Michigan versus Kenneth Bledsoe, 25-00012. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Bledsoe, who is approaching council table now, and if I may approach, Your Honor.
Yes.
Appreciate advice of rights and report for no contest plea. And I have highlighted the relevant portions of the report for you. I believe it's on the last page.
Okay, so the intention is to do the factual basis to the original charge.
Yes, Your Honor, that is correct.
Got it, okay. And so the offer is to plead no contest to trespass under MCL 750.552. That's a misdemeanor, maximum penalty 30 days in jail, $250 in fines. You understand that
Yes, Your Honor.
as the maximum penalty, and you want to plead no contest? What's the purpose of the no contest?
Civil liability.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Put your hand down. Okay, you have the right in this matter to proceed to trial. You would have to give up your right to trial if you wanted to proceed this way, which also means you're giving up your right to the presumption that you're innocent until proven guilty. You understand that? You have the right to see, hear, and question any witness called to trial to testify against you. You would have to give that right up, as well as your right to remain silent, not have silence be used against you. Your right to have witnesses subpoenaed to testify on your behalf as well. You understand that? Is anybody threatening you to get you to give up your rights and enter a no contest plea?
I'm sorry.
Is anyone threatening you to get you to enter a no contest plea today?
No, Your Honor.
Any promises being made to you if you give up your no contest? I mean, you give up your rights and plead no contest?
No, Your Honor.
Is there restitution at all?
I was going to put down the record, Your Honor, part of the basis, I think, of this, the civil liability claim is that apparently the defendant has already entered into an agreement with Kroger with respect to restitution. So since the parties have already started that between themselves, we're not asking for restitution.
Okay, sounds good. We understand that by entering a no contest plea, it could result in a conviction that may have impact on travel or immigration status that you may see. It also could be a result in conviction that you may need to report to your current employer or to a future employer. You understand that? Okay, as to the amended charge of trespass, do you plead guilty, not guilty, or no contest? Do you understand what's going on? So the request was for you to plead no contest versus guilty to help you avoid any potential civil liability. Civil liability is where you can be sued and you have to pay money back. You understand that?
This is what we discussed in the hall, if you're gonna be guilty, we ask you a series of questions. You contest have the effect of guilty, but rather than you answering the questions, judge reads a police report. Submitted, accepts it. So did you want to move forward with the no contest plea that we discussed? Right, you're accepting the offer that reduced charge of trespass, but you do so without answering the questions yourself. You would plead no contest if that's what you want to move forward.
Do you understand what's going on, sir? Feel free to let us know. It's not that we're here to help you understand. I just need to know if you need more time to have it explained to you, which that could be another brief conversation in the hallway if that's what you need.
That's a question or two. Would you mind if we took just a minute?
No problem.
Thank you very much.
Sorry, Your Honor.
You're fine. Back on the record. In the matter of,
Oh, Your Honor, I just want to say, Mr. Nagel. go ahead, real quick. And at this one moment, I think he's speaking with the witness to the trial. Ms. Dawn was not given.
she gave us a worksheet. Yeah. Okay, back on the record, in the matter of the state of Michigan versus Kenneth Bledsoe. We were in the middle of taking a no contest plea and we wanted to ensure, Mr. Bledsoe, that you understood the differences in the types of plea. You understand now?
Yes, Your Honor.
Okay, so as to the amended charge of trespassing, how do you plead? Is it guilty, not guilty, or no contest?
No contest.
Did you understand what we talked about in the hallway about the differences between them? The guilty is you answering the questions about whether or not you're guilty of the charge with the Michigan too. No contest is the effective guilty, but we've submitted a report to the judge to read. You want to do that? So would you like to plead no contest today?
Okay, I have a police report here from the Lansing Police Department, case number 25519000096, alleging that on or about January 4th, 2025 at 10:04 in the morning, officers were dispatched to the area of 443 Mall Court, Kroger. Full report of a larceny. Officer spoke with, let's see, it says. Okay, I understand what's going on. Mr. Bledsoe was an employee there, associate of the Kroger. Was noted in a address on the search random with meat less than X pounds on, it says December 24, 2024. Associate Kenneth Bledsoe purchased 8 beef shank cross-cut packages, each package scanned with a weight between 0.38 and 0.68 and price between $2.19 and $3.87. This I ran an item movement for this item and it normally ranges between $8 and $10 and weighs an average of 1.5 pounds each. The additional factual basis.
No, Your Honor.
Nothing further.
The court is satisfied with the factual basis. I find the reason for the no contest plea to be appropriate. Entry of guilty would be entered by way of no contest plea as to the trespass. Any objection to immediate sentencing?
No, Your Honor.
I would request it, Your Honor.
Fine is $250. When will you make payment on that? Okay, have a seat. We'll get you over to criminal traffic as soon as my officer is available, okay?
Thank you, Your Honor.
Thank you. Okay, this is the matter of the state of Michigan versus James Molinak, 24-03623, appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
No, no, folks, I'd like to be happy with that.
Okay, Mr. Malick has a retail fraud second. I see that the people have offered for him to plead guilty to amended retail fraud third under MCL 750.356D4. No objection to immediate sentencing, and restitution is owed to the Meyer at 6200 South Pennsylvania in the amount of $103. Is that complete and accurate as to the offer?
It is, Your Honor.
It is, Your Honor.
You want to accept that, sir?
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
Yes, Your Honor.
Okay, you can put your hand down. This advice of rights is stated for today. There's a signature at the bottom. Is this your signature?
Yes, Your Honor.
You understand the rights here?
I do, Your Honor.
Are you willing to give up these rights to plead guilty to the retail fraud third?
Yes, Your Honor.
You understand that that means you give up your right to be presumed innocent. So you're innocent until proven guilty, and you can require the prosecutor prove your guilt by proceeding to trial, at which time they'd have to prove each element of the charge being brought against you beyond a reasonable doubt. You understand that, right?
Yes, Your Honor.
You want to give that right up?
Yes, Your Honor.
You also have the right to remain silent at any trial and not have silence be used against you. You can waive the silence and testify at your trial if you like, and you have the right to see, hear, or question any other witnesses the prosecutor calls to testify against you. You have the right to subpoena witnesses to trial to testify on your behalf. You understand those rights that you'd also be giving up?
Yes, Your Honor.
Anyone threatening you to get you to give these rights up?
No, Your Honor.
Any promises being made in exchange for you entering a guilty plea to the amended charge?
No, Your Honor.
Are you currently on probation
No, Your Honor.
or parole?
No, Your Honor.
I understand that a guilty plea could result in a conviction that you may need to report to a future or current employer.
Yes, Your Honor.
It also could have impact on travel or immigration status that you may see.
Yes, Your Honor.
As to retail fraud in the third degree, how are you pleading?
No, Your Honor.
Factual basis, counsel?
Well, let me take you back to September 25th of 2024. Were you in the Myers on South Pennsylvania, the Lansing County, Maine, State of Michigan?
Yes, sir.
Did you take the items that were offered for sale?
Yes, sir.
Was it a Stanley tool set?
Yes, sir.
And did you take that without paying, and you were going to take it and use it yourself? Is that correct?
Yes, sir.
And you had no authority to do that?
Yes, sir.
I have no further questions.
Any questions for the prosecution?
No, Your Honor. People are satisfied.
The court is also satisfied with the factual basis. I'll accept your plea if finding your plea you may plead voluntarily and intelligently. My understanding is that he's been in custody since the time he was arraigned on this.
Yes, Your Honor. And he's actually spent already 256 days in Clinton County without date there, 3 days, March 17th, 2000.
Let's have credit for that, though.
Oh, no, I know he doesn't get
He
credit.
doesn't
but-
have credit for anything in here because he had a PR bond. I don't know why they do that. Okay, 1 day Ingham County Jail credit. Time served. Obviously, he had to be brought over here at least to be arraigned. And then the restitution ordered $103 to Meyer at 600 South Pennsylvania. Any additional matters for the record?
No, thank you.
I have none, Your Honor. Thank you.
You're all set. Okay, let's see. We see Monet Carroll.
Yes, Your Honor. He wasn't sitting.
Okay, on the record in the matter of the state of Michigan versus Monet Carroll, 24-03475, appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Ms. Carroll.
Okay, Ms. Carroll, let's see, has a pretrial for abandoning cruelty to an animal and 2 dog license vaccination matters. How are we proceeding on it?
Your Honor, the licenses in question have been brought up to date, and with respect to the animal cruelty, the conditions that were in question were addressed between the animal control officer and the defendant, and corrections have been made. The animals are healthy, and based on the compliance with the law and the condition of the animals, at this point, the people are prepared to dismiss this file.
Motion to dismiss is granted and we'll print a dismissal for the file. Do you have any questions today, Ms. Carroll?
No, Your Honor.
Thank you. Any additional matters for the record, counsel?
No, Your Honor, thank you.
No, Your Honor.
You're all set. Record in the matter of State of Michigan versus Clayton Dawson, 19-04300. Appearance, please.
Good morning, Your Honor. May I go for the people?
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of, right there, on behalf of Mr. Dawson, who is standing to my right.
Okay, Mr. Dawson has a child abuse for and a domestic violence from about 5 years ago. Let's see, how are we proceeding?
Your Honor, at this time, we'd be asking for a final pretrial. I don't believe an offer has been extended at this time. Mr. Nagel would like to look into that and then seek the final pretrial.
Final trial, February 24th at 8 a.m. Jury trial, March 3rd. Do you have any questions about those dates, sir?
No, ma'am.
We're gonna get you a copy of your notice to appear. You must appear in person for those court dates, okay?
All right.
Do you have an address for you, sir?
Right now is 916 West Kavanaugh, apartment 10.
Apartment 10.
Yeah.
What's your phone number?
Area code 248-212-4310.
Any additional matters for the record, counsel?
No, Your Honor.
Nothing further.
We'll get your notice in just a moment, sir.
All right.
Mrs. Donnelly isn't here. I just have a quick question. For Mrs. Donnelly, and Mr. Nagel.
Yes, Your Honor.
On the jury trial matter,